We should act together to ensure charter rights are respected and protected. Peter Lougheed, yes, the same Alberta Premier and champion of the clause, he offers us a useful way forward. Because 25 years ago, he argued for 3 straightforward amendments. First, if the notwithstanding clause is used, a legislature should be required to spell out with specificity very clearly the purpose of the law. 2, such an extraordinary measure should require a higher level of authorization than a simple majority. Lougheed argued here for a supermajority of 60%. I would go higher than that, but the general point stands. 3, there should be no preemptive use, none. No preemptive use of the clause. It should only be used after careful consideration of a judicial decision. Now, our Supreme Court can and should address this last point at least in part, because if anything good comes from the Bill 21 case, it'll be that judges can still weigh in with reasons that explain whether or not a right has been unreasonably infringed, even if the notwithstanding clause prevents a more meaningful judicial remedy. Of course, that paper judgment might help inform public debate, but it means very little to those who have had their rights infringed.